flour barrel left an upper floor and struck the street below. No witness saw the careless act or why the load let go. The injured man could prove the harm, but not the hidden breach. Then ordinary experience asked, do barrels fall when handled carefully? Negligence usually asks for proof. What duty was owed, what care fell short. But sometimes how the danger worked is hidden inside another's hands. The rope, the stack, the loading floor were managed out of sight. The claimant stood outside the place with only what had struck him. He could not name the careless hand or trace the final slip, but stored things do not leave their place if reasonable care has kept them. The cause was hidden, the pattern was not. The accident entered the witness box. Res ipsa loquitur, the thing may speak for itself. Not liability by magic, not a verdict from the harm. But when this kind of accident would not ordinarily occur, if those who manage the danger had used reasonable care, the proven facts may raise an inference of negligence. No witness saw the careless hand, but the accident could speak. Would this event ordinarily happen if reasonable care had been used? Second, who managed the danger when the likely failure began? Is the true mechanism unknown after the claimant proves the facts? Unusual event, defendant-linked control, unknown mechanism, inference drawn. Control is not mere ownership or every second in one hand. It asks who managed the danger and whether the fault points there. A car leaves its proper side, a stored load falls from above, an object stays inside a patient where careful surgery should leave none. But different facts, the same question, does the event call for explanation? Res ipsa loquitur, the thing may speak for itself. The claimant need not reconstruct each hidden second of the breach. A proper set of proven facts may make negligence the likely cause. Then any answering evidence must weaken what the facts suggest. The cause was hidden, the pattern was not. The accident could speak. But speaking is not judgment. The inference can be met. The defendant may show another cause or reasonable care despite the event. A sudden hazard no care could find. A stranger's act beyond their control. A defect reasonable inspection could not discover or prevent. A possible story is not enough. The evidence must change the weight until negligence is no longer the proper inference from the case. The legal burden stays with the claimant from the begin to the end. But the need to answer grows when unexplained facts point one way. Not every fall speaks clearly, not every injury proves a breach. Some accidents have many causes, some point equally elsewhere. If evidence shows the actual cause, the court must weigh that proof. The maxim serves the missing mechanism, not a substitute for truth. It does not replace the duty, causation, damage, or the claim. It helps the court infer a breach when direct proof cannot name it. It does not say someone was hurt, therefore someone must have failed. It says these proven circumstances may justify negligence inferred. There's Ipsa Loquitur, the thing may speak for itself. The event becomes circumstantial proof when the precise breach cannot be shown. The court asks what normally happens when reasonable care is used. Who managed the conditions and whether other evidence explains them. If the inference survives the answer, the claimant may cross the gap. No witness saw the careless hand, but the accident spoke through the facts. The barrel lay upon the street. The upper floor stayed still. The precise cause had not been seen. But law can hear an accident without pretending it said more than the evidence allows.